Yes. Yes.
Are you ready? That board tag.
We are. We're on record. All right. Okay.
Thank you again. On behalf of Volusia County, the Department of Public Protection, Division of Corrections, I want to thank you again. We appreciate your time and your attention here today over the course of this appeal. It's an honor to be before you, and I've told you that before, but your volunteer service is immensely valuable to the county. So I can't, no matter how you rule today, I can't tell you that enough. But before I discuss the violation and the evidence in detail, I want to remind the board respectfully that the board's role is to consider all the evidence and that's before you today. So your testimony, receive some exhibits, and decide whether the department's determination is reasonably supported by the evidence and is not arbitrary, capricious, or discriminatory. Our position, of course, is that the department's dismissal of Richard Kerns is supported by substantial evidence and that your examination of the record before you and any inference that you draw from the record evidence is such that on the basis of that record, a reasonable person acting reasonably might have reached the same decision as the department directors. We believe Mark Flowers' testimony alone is sufficiently substantial evidence that his testimony remains uncontroverted. You might ask yourself, how many times does it take to terminate an employee for the same offense? Ordinarily, pursuant to principles of progressive discipline, it takes 5 disciplinary actions to dismiss an employee. It starts off with a counseling, written reprimand, a suspension of 1 day, a suspension of 3 days, and then termination. That's typical. Here, we've had more, Mr. Kerns has had more than ample opportunity to correct his behavior. You heard testimony from Mark Flowers that, in his judgment, he's not going to be able to do that. This appeal may remind you of the witty quote often attributed, sometimes misattributed to Albert Einstein, that the definition of insanity is doing the same thing over and over again, expecting a different result. That's a little bit how management feels like in these sorts of instances. Mr. Kerns' absences have an adverse effect upon the jail. Director Flowers and Mr. Kerns himself testified about some of the adverse effects of his unscheduled absences. Mr. Flowers also testified that the Volusia County Jail houses inmates, people charged with serious crimes. The jail's not run, so we need the people, his corrections officers, to show up when they're scheduled. What is before you in the notice of dismissal, and that's pages 2 through 5 before you, is finding that Mr. Kerns violated Volusia County Code sections 86, 453, 2, 15, and the Division of Corrections policy 102.02 and 102.09. That's what you're going to be asked to rule on today. The main offense I want to draw your attention to is 86-453, which makes it a disciplinary offense for an employee to have frequent absences from duty without prior approval. Policy 102.02 is closely associated as it makes clear that patterns of unscheduled absences are subject to disciplinary action. We've proven a pattern of unscheduled absences that are predictable. Policy 102.09 requires employees to be reliable and dependable, to obtain prior approval before being off work, and to schedule leave in a manner that minimizes work disruption. Section 86-453-4, policies 102.02 and 102.9 are predicate offenses for a violation of section 86-453-2. Which makes it a disciplinary offense for an employee to frequently violate county ordinances and departmental policies and regulations. We would ask that you waive, or I'd ask you to dismiss or not sustain the offense related to unsatisfactory performance of duties. You can't contest that it's really uncontestable that his unscheduled absences will diminish his performance. But I'm not gonna kid you, I'm not trying to get you to rule here today that his performance has been unacceptable. It's the unexcused absences that are unacceptable. And I think you know that, realize that. Mr. Kerns' management has been monitoring his unscheduled absences and has recently discovered Mr. Kerns' absences and the pattern of such unscheduled absences. Their management of his unscheduled absences and the discipline that they have, the effort that they have put into the discipline and administering the discipline and managing his unscheduled absences takes a lot of managerial effort. And again, this is of a 15-year senior corrections officer who's been warned time and time and time again to correct his behavior. He took the stand and testified on his own behalf that, he had diarrhea in 2016 on some of these episodes, but, if he went back to work, he can't stop it. That's sort of asking for a blank check. The uncontroverted evidence that's before you in the form of the exhibits and testimony of Mark Flowers shows that Mr. Kerns committed the violations he's charged with. Now, with respect to propriety of the department's termination of Richard Kerns, your own rules state that the board should not substitute judgment and discretion for the judgment and discretion exercised by the director. If the director has demonstrated that he has acted in good faith upon a fair investigation and has imposed a penalty that is not inconsistent with those imposed in similar cases. Only when a penalty is obviously excessive, unreasonable, capricious, or arbitrary should the board substitute its judgment for that of the director. The county has already attempted to terminate Mr. Kerns once before, in July of 2015. I walked you through all the warnings that he had gotten previously, all the invitations for help and assistance during his cross-exam. Nevertheless, the department gave him yet another chance. They reduced that July 2015 notice of intent to terminate to a suspension, giving him yet another chance. They took him off, mandated that he not perform any overtime, but as soon as he was allowed to work overtime again, the same patterns came up again. But even before we got to those absences, in January 2016, he was suspended yet again for insubordination. That's disconcerting for a senior corrections officer with 15 years of experience. And it distinguishes him from Rebecca Blair. There's no evidence that the department's determination of Richard Kerns is excessive, unreasonable, capricious, or arbitrary. There's no evidence that the director's termination of Richard Kerns was not made in good faith. Similarly, there's no evidence that the pre-termination investigation was unfair or otherwise impartial to Richard Kerns. Instead, the uncontroverted evidence shows that Richard Kerns had unscheduled absences before scheduled days off, and during periods in which he had worked overtime. And these patterns are consistent with Mr. Kerns' unscheduled absences during the period of 2013 through as late as early as this year. There's no basis whatsoever for reducing his dismissal. Mr. Kerns has been disciplined previously. It's before you. And consistently for the same offenses and that prior discipline, including an intended termination in June 2015, has not caused him to change his behavior. Now, I want you to point out that his testimony is that for 6 months, he was able to change the behavior. But then he repeated the same patterns again. He has simply run out of chances, and he's had many. I want to talk about Rebecca Blair. She's a corrections officer who, like Mr. Kerns, has had a significant number of absenteeism issues. But when she was given her last opportunity, she corrected her behavior, and she has received 4 Caught in the Act awards. That distinguishes her from Mr. Kerns, who, since he was issued the notice of intent to terminate in July of 2015. He's received no Botany Act awards since, or if ever. And he's sustained or suffered a insubordination discipline. For the foregoing reasons, the evidence that's before you, based upon the testimony you heard from Mark Flowers, we ask that the board make findings of fact and conclusions of law, upholding and sustaining the director's dismissal and termination of Richard Kerns from employment with the Volusia County Department of Public Protection and the Division of Corrections.
Yeah, thank you. Thank you for your audience today. To say the obvious, okay? If we were here, as I stated in my opening statement, if this decision was up to the county, and we have no doubt what Director Flowers wants, he would be terminated, that would be the end of it. But it's not up to the county. It's up to this board to determine whether there's cause for Mr. Kerns to be terminated from his employment. And we contend that it is not. So obviously, this is not the county's decision. That's why we're here. We're under the procedure of due process. Now what do we have? Clearly, Mr. Kerns has been employed by the county for 13 years. Other than absences, he's got one disciplinary action. And we would ask that you consider the testimony he provided here today, that he was credible. Okay, why do I say that? There's not one piece of evidence that any time that he was out of work, that it was for anything other than illness. That's why he testified his illnesses is why he was out. We don't have any evidence otherwise. They didn't call him in to question him, etc. We have he called out on time. He gave them sufficient time to get someone else or to reorganize the ship commander. He followed all of those procedures. He wasn't tardy. When he was left in the middle of the day at work, he asked his supervisor. Now, why are these things important? Why is that? Because we don't have insubordination. We don't have somebody that's not following the lead policies. We don't have an officer that's not respectful to his superiors. I don't know what other cases you have. We don't have any evidence like that whatsoever. In fact, he's remained a senior officer all of these years. He could have been demoted. Any number of things could have happened. He enjoys his job. He testifies he likes working with his co-workers. Now, I'm going to try and address some of the points that they brought up. When we're talking about illness, they say it's consistent. He keeps being warned. The record doesn't show that. We're not saying that Mr. Kerns does not get ill. He doesn't have health issues, and we're not here to say if he went back to work, he would not have any health issues. He may get sick. Nobody can predict what's going to happen in the future. Nobody's going to say somebody is not going to get sick. They're not going to get ill. These things happen. It happens. However, the record does not show it's a consistent, where he's consistently ill. Even their own records show in their own disciplinary policies, okay, that he was disciplined in 2007, no problems for 3 years. It's not a man that takes off whenever he wants, with the trying to say consistently. Okay, there's 3 years he was not ill at all. At least he wasn't disciplined for illness. He had, again, 2011, he had a schedule in 2010, 2011, no issues in 3 years between 2011 and 2014. We don't have any disciplinary actions during that 3-year period of time. This is their own records here. He had issues in 2014, and he did have issues in 2015. more significantly, we've established from 2015 to August of 2016, he had 3.5 days off. Okay, that is less than that, and again, their policy is 60 hours. Even Director Flowers indicated during their rolling period, he was well below the time. Now, again, they're trying to say that it's a pattern. He takes off, he schedules his time off. We're saying that it doesn't establish a pattern. He had, again, clearly, he had sick time, personal leave he could have used. So during that 13-month period of time, again, 3.5 days off of all of his shifts, 42 hours. If we do the math, that's 1 day every, you want to look at it, 1 day every 3 months maybe. I mean, the amount of time that he took off doesn't establish a pattern. Shows that he's home and he's ill. You know, did he happen to be ill on December 31st? That's possible that he got ill on that day. We have no evidence otherwise. You can see they've alleged in the notice of intent that he was taking off. It was scheduled around overtime issues or to extend his time. If you look at his schedule that he described, he works 4 days and 3 days. A lot of times when he would be ill would happen to be on a day where the next day he would have off. It's not a pattern here. I even acknowledge it looks like a pattern, but there's no evidence that it's a pattern. He had a full 6 months where he did not take off at all, from May until August, 2.5 months to the time he was put on suspension. We have no time, no days off. Now, we have no evidence that he was thinking, well, I'm going to be suspended, I better stop taking off. That's a 2.5 month period of time. There's nothing in his attendance record showing that he was off, took off at all during that time. I might add also, they have policies, that state that if someone takes off, they're penalized. Your personal time gets lowered. It affects your vacation time. He's testified. He likes to work with his coworkers. He doesn't like the opinion of his coworkers, that he's taking off. His reputation is important to him. We contend that works on the opposite end, that he's taking off because it's a pattern. He's scheduling time off for these particular reasons. He testified. He has grandchildren at home, little grandchildren. They get ill. That's not unreasonable for that to happen. And I want to add, in their notice of intent to dismiss, they acknowledge that they made an error. Now, they've had lots of documentation. Even Director Flowers made a note. The first time that he was out, on December 31st, that shouldn't have been put on his record because it was less than half a day. Now, we're talking about a man's life and his career. And I'm not saying we don't make errors. We all make errors. However, that's his notice of intent to dismiss. We ask you to consider that they've made an issue out of that particular day. Even Director, it's additional time he took off. They have to follow their policies and procedures as to the unscheduled absences. They lay it right out. It's got to be if you take off more than half a day. It says i.e. more than 8 if it's an 8-hour day, but here we have 12.25 hours. We ask you to consider that fact as well. He's got his employment evaluations are either exceeds, lower end of exceeds, or they're satisfactory evaluations. We went back several years. Okay, this is not a problem employee. This is a good employee. Again, this is your decision. Now, I want to come back. Okay, and this is going to take me a few minutes, and I apologize because we didn't get through this. Okay, but they brought up Senior Officer Blair. They brought her up. We didn't bring her up. She's doing great. She was given a last clear chance, and she's doing fantastic. She's got all of these accolades now, caught in the act. And I might add, one of the caught in the act is that she did not report and he absences, I think, for 6 months. But, you know, he's 1 day short of 6 months from July to December. He didn't get that. I don't know why, but it's 1 day short. But that's one of her caught in the acts. But I want you to look at her record, okay? I hate to bring this up because it's right, I presented it to you on here. And I'm just going to go, I'm going to do this quickly, but I think it's important to look at her record. Again, this is their employee that they said is not comparable. 1998, failed to follow policy and procedures, spoon cup pickup. 1999, excessive leave, 15 days in 7 months, required to provide medical certificate for any sick time. 1999, established pattern of calling out sick when assigned overtime. Calling out sick when assigned overtime. Required to provide medical certificate for sick leave. 2000, written reprimand, called out sick, going into AWOL, absent without leave status.
I'm going to voice an objection. You know, none of that's in evidence.
We allowed it into evidence.
They didn't offer it into any evidence.
Which
You're
part?
reading something into the record.
Which part of that did you not include in evidence? Sorry.
It's the letter, October 31st, on this Blair, Officer Blair.
We looked at it, I don't know if it was ever
Admitted into evidence.
in this evidence. I don't think it was. Wait a minute, I never said.
2001, failure to observe established work hours, repeated warnings for being tardy. 2002, absenteeism. 2002, excessive absenteeism counseled. Memorandum, allowed to leave early with AWOL status to avoid absence for entire day. 2002, written reprimand, called out putting yourself into AWOL status. Record of counseling, 2002, note on notification of relationship with an inmate or ex-inmate without approval from the director. 2003, 1 day of excessive absences. 2004, 4 days for failure to report for duty during Hurricane Francis. 2004, 1 day for absenteeism. 2005, 2 days for absenteeism. 2007, excessive absenteeism. 2008, tardiness. 2008, excessive absenteeism. 2008, suspension 1 day for excessive absenteeism. 2008, written reprimand, insubordination, failed to provide a police report for leaving early due to emergency. 2008, tardiness. 2009, excessive absenteeism. 2010, excessive absenteeism. 2011, excessive absenteeism. 2011, 3-day suspension, excessive absenteeism. 2012, unscheduled leave. And what happened with Officer Blair? Last clear chance, demotion. Do it again, sign an agreement. Okay, he was never given that opportunity to do that. We can compare her record with his. He was never given that opportunity to do that. They said, well, she's doing great now. Okay, she's doing great. She was told. She signed an agreement, last clear chance. He was never given that opportunity at all. So, again, is this fair? Is it, we contend? And again, Director Flowers was not here at the time, but he clearly had this information in front of him. He said he didn't read this over. He didn't remember all of this. I mean, I think it's important. You have to consider that. We'd ask you to consider that. You don't have to do that. We'd ask you to consider that. Is it fair? If he signed the last clear chance agreement, maybe he's getting all that he's caught in the acts also. Maybe he would. We don't know. And again, we can't guarantee he won't be sick if he gets. He can't get anybody will not be ill. They have policies and procedures in effect for someone's illness. It's more than 60 hours. We can get what it is now, but over a rolling period of a year, that's what they have. Those policies, as far as we can tell, would still be in effect. for Mr. Kerns. So we would ask you to consider that. Changing his behavior, they want to change his behavior. I'm not sure what that means. If you're ill, you get ill, unfortunately. And again, we can't, there's no guarantees here. We would ask just to consider the evidence as a whole here. Consider his record as a whole in terms of his duties as a correctional officer, senior correctional officer at the Volusia County Branch Jail over 15 years. We would ask, as your discretion, either to make a finding that there has not been a violation of the policy because he was not over 60 hours in the last rolling period. We'd ask you also to consider that that's not the case, that if that is the case, to consider the level of discipline, whether this is fair, okay, and whether he can come back to work and he can be an employee that contributes successfully to the county. Thank you very much for your attention.
In their close, they've invited you to ignore the evidence. Mark Flowers took the stand, and we established two patterns. They've also invited you to misconstrue the policy that's at issue here. The policy allows for discipline if you exceed 60 hours. The policy also allows for discipline if there is a pattern of unexcused absences. That's what we're here on. They're riding the 60 hours, we're not riding the 60 hours. That's why the 42 hours, when you break it down and you look at it, and if you can establish a pattern, which we have done through Mark Flowers' testimony, discipline follows. The pattern is classic. You've heard about it. We work Monday through Friday, not out of corrections, but we work Monday through Friday. Our last day and our scheduled week shift is a Friday. You see that person taking that day off, then that's a pattern. Or it could be a Monday. Out of the jail, the pattern you see, and we walked it through what happens on the last day of his 3-day and 2-day shifts before 2 scheduled days off or more. All right. Classic manipulation. The record consistently shows that he calls out on an unscheduled leave on the last day of a scheduled 2 or 3-day shift. They talk about Rebecca Blair. Read into their clothes somewhere in disciplinary history. That's true. There are 2 things that distinguish Rebecca Blair. And Director Flowers testified about those 2 things. One, she accepted responsibility and showed remorse. That comes right off of the same disciplinary document they were reading, yet they want you to ignore that part of it. Mr. Flowers testified that Mr. Kerns didn't accept responsibility. He's taken the stand and testified today. He's still not accepting responsibility, and he hasn't shown a lot of remorse. He didn't show remorse toward the director. Today, of course, he wants his job back. He's going to tell you whatever you want to hear. I would ask you to focus on the record of evidence that you've heard from Director Flowers. There's a pattern, and it showed you what the pattern was. He also testified with respect to Rebecca Blair that if she comes up to his level again for discipline, he's going to terminate her. Thank you very much for your attention.
All right, I think, anything else like that? Typically we don't, but if you want to have a last word, go ahead.
Yes, just I'll just be brief. If they have concerns, we can go around and about if there's a pattern regarding the overtime issues, whether he takes off around that. They told him at some point, it's in the record, if they have an issue, they can tell him no overtime. That's what they can do. We can go around and about, he's testified, he was sick, there was no pattern. But if that's the concern, it's in the record, that says no overtime for 6 months, that they can do that. Nothing further.
All right, thank you both for your presentations. I think that one of the interesting things about this hearing is a couple of things. One, we're not the determining board, obviously. We're an advisory board, we're a fact-finding board. And we can certainly do thoroughly hear these cases. I think that, there's not been a case that I can recall where we don't hear the facts presented out 3 different ways. And it does get a thorough vetting of these hearings. I appreciate your presentations and willingness to try and keep it as short as possible and to get their points made. So anyway, that said, we'll do the best we can to find some, read the records and find back to the age of Mr. Dean and his decision whether or not to uphold this determination. That's what we're here for. So, I think the best way to break this down today would be to approach the county merit rules and regulations as presented on page 2 or 4 on the notice of determination, where it says, we all on the same page we're discussing. It goes with the subsection disregard proven violation. That we're all on the same page. All right, anybody want to read or opine on what we heard today? Get your feelings and questions on the record.
Can I ask a question before we on that? Could someone on the board or somebody, what's this last chance agreement stuff? I don't quite understand it. Is it an obligation or is it discretionary or what is it? Discretionary?
That's my understanding. I'm not an expert on it.
I've never heard of it before. That has been mentioned in other hearings where they're given a last chance.
What is it?
A last chance meeting, a last chance,
Okay.
something.
I don't think it's laid out.
I'll rephrase my
But it's
question.
not.
From a legal standpoint, it has to be a mutual agreement. So if we're talking about a formal document where it says, we were going to terminate your employment, but we, the employers, decided to give you a last chance, and has the terms of which that individual would get a last chance, it would have to be a mutual agreement. So versus the board, if you say, here's a last chance agreement, sign off on it, that is an involuntary condition. So the last chance agreement is a formal procedure where the two sides come to mutual agreement. Or, alternatively, the employer says, under these terms, we're willing to give you another chance. And if they say no, well, we were going to terminate your employment for that. So that is what the legal phrase last chance agreement is. It's actually a contract.
On the Volusia County personnel policy, what policy is that?
Okay?
Not in the policy.
So it doesn't exist?
Yeah, I can't answer that. That's a legal option, but whether or not it's in the county policies or not is another issue altogether.
They're saying it's not.
So if it's not in the policy, why do we keep hearing it? That's not, okay, I'm done with it.
No, I think that's a reasonable question.
It's a good question.
It just confuses stuff.
It's just one mechanism that they can use to, course of action, try and sort it out.
But why? It's not the policy. Okay. Thank you.
But even without that type of contract, I would think an employee, if you have many suspensions and you have lots of letters of reprimand, and it's pretty much all of them for the same reason, that would be a clue that you needed to change, but even though he says it's not behavior, or sometimes they will say that, but that somehow something has got to change.
Oh,
I've said this many times, I thought this about, when is enough enough? I mean, doesn't it give you a clue if you continue that same pattern? But anyway, you
Well,
asked for it.
It's clearly not in the procedure of progressive disciplinary actions.
Okay.
Just one of those that comes up and not all the time.
Probably some see it, that's the last chance, you know, to change or something.
Well, how do we feel about specifically about findings of fact about whether or not Mr. Kerns violated county merit system rules 86-453?
Except for that last, in my opinion, except for that last unsatisfactory performance of duties. You looking for a motion?
Well, no, I'd rather just talk about it. But I think we all are okay with the deleting or not considering that number 10 subsection under there, for the unsatisfactory performance of duties. So maybe everybody.
Yes,
Yes.
yes.
All right. Okay, as far as the disregard, number 2 and 4, how do you feel about those?
I definitely feel like they've been violated.
I haven't heard any evidence. I think it said that it wasn't there.
You having trouble hearing?
Repeat that again.
I don't recall any evidence of disregard or frequent violation of county ordinance, departmental policies, regulations, and safety rules, except for the frequent tardiness or absence. So, I mean, he didn't violate any safety rules that I saw in any of the evaluations. Of course, you can, violation of county ordinances and departmental policy that is in regulations, that's a broad brush.
It did say in his evaluations, and I did not know which ones, but it frequently said for him to learn the policies, for him to improve on those policies. I don't remember that it
The
actually
continuing training.
violated, it said anything about violation, but it just kept reminding him about, in the evaluations, about improving on those policies or learning them.
Well, if I may, my interpretation of that phrase is that one of the primary departmental policies is that you show up to work when you're scheduled.
Yes, I agree. I was going to say the same thing. Plus, considering the job there with the corrections and the type of, as he has mentioned, the inmates and all that, and if one does not show up and it's unscheduled and they cannot get someone to cover, to me, that's a safety factor for the inmates, for being able to go on with the procedures that you have for them, whether it's the recreational or whatever. So I would think 2 and 4 apply, but 10 doesn't for that one. Well, I don't know, we're looking for one.
No, I agree. No, that-
Yeah.
I agree, especially because of 4. I'm not so sure about 2, but you've got 4 in there, and yes, I agree.
Well, I don't think we've heard a lot of surprising new information. We had, I think, sort of a failure to agree on why, we've tried to come to a conclusion of why he doesn't show up. And, people do get sick, we can help with get you sick. But it's not up to us to determine causation, it's just the facts on the table. It's he didn't come in a lot, and it's a problem for the department to the point where it's almost, that's the only revenue to it. So anyway,
So where are we on this?
do I hear a motion to uphold or not uphold that section of the Volusia County Merit System?
I make a motion that we uphold section 86.453, 2 and 4, and do not uphold 10.
Second.
Motion and second. Any further discussion on that motion? Hearing none, all those in favor say aye.
Aye.
Opposed, like sign. Motion carries. Let's talk about the next section. Volusia County Division Correction Policy Procedures 102.02 and 102.09. first one, 102.02, boils down to the patterns that have been brought up that were of concern. How do you feel about that one?
I definitely think that one's not been held up. Plus the fact that, you know, if it is a sickness issue, the fact that no time during all of these years was a doctor's evaluation ever sought to evaluate him and put it in a personnel file. So the only thing that you have is the fact that he just doesn't show up. You know, he has these unscheduled absences.
I have been a supervisor before. I had 102 people under me, and if someone does not show up, it is a hardship, no matter what job it's in. No matter what job it's in, it's a hardship. And then when you have an employee who has a pattern, that is an absolute cause for concern. And not only is there a pattern that was pointed out, but I was looking at his evaluations, and on 5 of the evaluations, evaluation 211-16, 5, 15, 15, 125-12, 1226-07, 116-07, it has language that says improve unscheduled leave usage. So it was documented in his evaluations for many years.
I've worked shift work too, where you had to call in sick, the person you called into, that was a moment of fear in my life to call in sick, because they would, you better talk a good line, or you know, people have to jerk their schedules around or pay overtime, and that was a concern. So you thought carefully about calling off, it does create a lot of problems coming down the line. A couple of the things that I noticed were the one, December 31st, where you left the shift early. That's, I know, you get sick, but that's a real problem. Even worse than calling in at a time like that, not matter. But then you have no notice of the guy going, oh, I'm going to get done in that kind of a situation. But it certainly is a problem. And I really like to be sitting go along. I just had to bring that up. So any more comments on this section?
A person can't help being sick. I understand that. But I also see a pattern.
I agree with that. You want to vote on these separately or as a group?
That's a group.
All right, let's just discuss, any discussions on the 102.09? Reliable and dependable. He was, I guess, did okay when he was there, but again, there's a lot of times he wasn't there. And that's uncontestable. Matter of fact, for the record.
I think on that 102.09, we need to, say on that one that it is to, for the section, to observe established work hours and schedule appointments, and then over to, and to obtain permission before being off work, and to schedule leave in a manner that minimizes work disruption. Because we're not saying he is, well, it says employees are expected to be reliable and dependable. I don't have any problem with that. For example, to show up for work, he did not show up for work, ready to work, I guess he was ready to work when he was there, but on a reliable basis, no, that was not a reliable basis. To observe established work hours and schedule appointments. Part of this, what I'm trying to get at is part of it, we should not rule on, as Michael was saying, we are ruling on 102.09 only on the unexcused absences.
Well, I think that when Mr. Deneen listens to our deliberations, he will take note of that exception. Considerations.
Yeah.
I love Mr.
move that on Volusia County Division of Corrections Policy and Procedure 102.02 and 102.09 be upheld as written. Applied as written, I don't know how do you do your motion?
Need a second.
Second.
Further discussion on that motion? We'll move on to criteria.
I'm sorry, I'm not hearing something.
Well, I withdraw it then. I don't need to tell you what I'm going to do next. Okay, any further discussion on that motion? Hearing none, all those in favor of the motion say aye.
Aye.
Opposed, like sign. Motion carries unanimously. And now we will move on to the propriety of the sanction portion of the hearing. I'm mumbling apparently, I know I did.
You are, there's not any school boards there.
I apologize, mumbling. How do we feel on this one? The county was joined in this dismissal.
Speak up, please.
Do we feel that the county has proven its case and the dismissal was warranted?
So moved.
Second.
We have a motion and a second. Any further discussion? Hearing none, all those in favor of the motion say aye. Motion carries unanimously. That brings us to the conclusion today. I appreciate everybody's time and patience today.
Yes, sir. All right.